Let's talk about some of the details about voting in the limited liability company. First, let's talk about relative voting rights, right? Members have voting rights. What are their relative voting rights? This is an issue that we've talked about several times already. Read your statute carefully. Read the statute of your jurisdiction carefully, because there are two different approaches. One is equal voting rights for all members. Each member gets one vote regardless of her relative capital contribution to the LLC. This is per capita voting. Some jurisdictions will have a different approach. They'll have voting proportionate to value of the capital contribution to the LLC. I've given this example many times. So imagine I'm a member in an LLC and you're also a member in the LLC. I invest $99,000 into the LLC. You invest $1,000. Well, our relative voting rights are very important, aren't they? And our relative voting rights will depend on our jurisdiction. So if we're in an equal voting right, per capita voting right jurisdiction, you get one vote and I get one vote, even though I've invested much more money into the LLC than you have. If we're in a jurisdiction that has proportionate voting rights, then I would have 99 votes to your one vote. Let's talk about voting generally in member-managed LLCs. Similar to the partnership, we're going to be voting on ordinary matters, extraordinary matters, amendment to the operating agreement, and admission of a new member. For ordinary members, we need approval of a majority of the members, right? The standard is similar, if not exactly the same, as our standard for voting in the partnership. Once again, just like voting in the partnership, members are not going to be voting on every ordinary matter. They'll only be voting on an ordinary matter if there is some sort of disagreement about that ordinary matter. With respect to extraordinary matters, we need approval of all the members. With respect to amendments to the operating agreement, we need approval of all the members. And with respect to admission of new members, we need approval of all the members. These are all default rules which we may change in the operating agreement if we want. Let's talk about voting in manager-managed LLCs. Remember, in some jurisdictions, when you file your articles of organization for an LLC, you can choose to be a manager-managed LLC. In manager-managed LLCs, voting on these matters is just a little bit different. With respect to ordinary matters, we need approval of a majority of the managers. Ordinary matters are for the managers to decide, not the members. And once again, the managers will not be voting on every ordinary matter. They'll only be voting when there is a disagreement with respect to an ordinary matter. Extraordinary matters, well, let's think back to the corporation when we had some sort of fundamental matter. If it was a fundamental matter, a fundamental transaction, the shareholders got to vote on it. And that's kind of the modus operandi of the manager-managed LLC. The members are very much like the shareholders in a corporation. So with respect to extraordinary matters, we need approval of all the members. With respect to amendment to the operating agreement, we need approval of all the members. And with respect to admission of a new member, we still need approval of all the members. Once again, we can change these rules in our operating agreement. If we have managers in our LLC, how do we elect and remove our managers? Once again, we have a manager-managed LLC, and we have to elect managers. Unfortunately, or fortunately, however you want to look at it, the statutes are not very specific about how we elect and remove managers. Remember, in the corporate context, when we discussed how do we elect and how do we remove managers, we spent a lot of time talking about what corporate law said about that. Well, in the limited liability context, the law does not say a lot. So looking at the Revised Uniform Limited Liability Company Act and the Delaware law, we see a couple different approaches. In the Revised Uniform Limited Liability Company Act, we say that managers are elected by a majority vote of the members. And that's pretty much all it says. If you want to have other voting mechanisms, then you can put them in the operating agreement. In Delaware, it just says managers are elected as provided in the operating agreement. So if you have managers in your limited liability company, the operating agreement should clearly spell out how we elect and remove these managers, because the default rule might not provide any guidance on this. Let's talk about meetings, proxies, and consents. Remember, in the corporation, we had annual shareholders meetings and regular shareholders meetings, and special shareholders meetings, and shareholders could attend shareholders meetings by proxy, and we even had situations where we had action without meeting by written consent of the shareholders. Can we do that in the LLC? And of course, the answer is yes. Formal meetings are not usually required by the law. So if you want to have formal meetings, you should put that in your operating agreement. Written consents, can we have member action without some sort of meeting? Well, the answer is yes. How do we do that? Do we need consents? Probably. Do we need written consents? Well, probably. And Delaware is explicit in that it requires written consents if we have some sort of member action without meeting. Finally, can we use proxies in the LLC? Well, the default rules generally say nothing about this, and so if you want to use proxies in the LLC, you should probably put it in the operating agreement. Let's talk about authority in the member-managed LLC. Can the members bind the LLC? Same general principles of agency authority that we've already talked about. Did the member have express authority? Did the member have implied authority? Did the member have apparent authority? But here we have a special apparent authority issue. It's the same issue we had with respect to the partnership. Your status as a member in some jurisdictions gives you the apparent authority to bind the LLC in ordinary business transactions. Once again, just simply by being a member, you have apparent authority to bind the LLC. Now, this is in some jurisdictions. In some jurisdictions, they say that a member does not have authority, apparent authority, to bind the LLC simply because she is a member. Now, she might have apparent authority for some other reason, right? Some past history or her title with the limited liability company. But her status as member in that jurisdiction would not give her the apparent authority. Once again, two jurisdictions, two approaches. In some jurisdictions, membership status gives the member the apparent authority to bind the LLC for ordinary business transactions. In other jurisdictions, your status as member in an LLC does not give you the apparent authority to bind the LLC. But in those jurisdictions, you might have apparent authority based on some other conduct or circumstance. Let's talk about authority in the manager-managed LLC. In a manager-managed LLC, the managers have the authority to bind the limited liability company, not the members. We still deal with the same general principles of agency authority. The express authority of the manager to bind the LLC, the implied authority of the manager to bind the LLC, and the apparent authority of the manager to bind the LLC. Once again, if you are a manager in a manager-managed LLC, you probably have the apparent authority to bind that LLC to ordinary business transactions. Finally, let's talk about member information rights in the LLC. Remember, we talked about shareholder information rights in the corporation. We talked about shareholder access to corporate books and records, and we said that most often a shareholder is going to have to show a proper purpose to access limited corporate books and records. We also talked about we also talked about a partner's rights to access partnership books and records. And we saw that in the partnership context, the partner had an almost unfettered right to access partnership books and records. And the reason for that is that the partner is generally involved in the day-to-day management of the partnership business and affairs, and therefore needs to have broad access to partnership books and records. In the LLC, we also expect that the members will be highly involved in the business and affairs of the limited liability company. And because of that, we would expect that our limited liability company statute would provide our members with broad rights to access the records of the limited liability company. So look for that in your statute. Naturally, if the LLC does not keep any books and records, it would be difficult for us to access them. And the statutes, the limited liability company statutes, don't always specify what types of books and records the limited liability company must maintain. Some jurisdictions do. Ohio, for example, has a long list of the types of books and records that the limited liability company must maintain, but otherwise, in other jurisdictions, the statute is silent on this issue. This should be in your operating agreement. And that is it.